Hello everyone. Welcome to latest update program. The topic of discussion is Supreme Court. This topic relates to Indian polity section of the UPSC CSE syllabus. President Droupadi Murmu has invoked the Supreme Court's advisory jurisdiction, Article 143(1), to seek the court's opinion on whether timelines can be set for the president and governors to act on bills passed by state assemblies. The reference comes weeks after the Supreme Court's 8th April ruling that set a 3-month deadline for the president to clear bills reserved by governors, a decision that overturned Governor R N Ravi, withholding of assent to 10 bills in Tamil Nadu. Before moving further, an important announcement. The offline batch of the IAS Foundation course, Prelims plus Mains, has started at Drishti IAS Noida. Admissions are now open for both the English medium and Hindi medium batches. For more details, contact 87501-87501. Now let's discuss key details on Supreme Court's advisory jurisdiction. Under Article 143(1), the President may seek the Supreme Court's opinion on important legal questions. But the Court's opinion is advisory, not binding. The Court may choose not to answer a reference if it finds the issue non-justiciable or already settled, as it has done in past cases. The reference will be heard by a 5-judge bench and includes questions beyond the April 8th ruling, such as the role of larger benches, use of Article 142, power to do complete justice, and center-state jurisdiction under Article 131. Now let's talk about: can the Supreme Court overturn its 8th April decision? The Court's 1991 opinion on Cauvery disputes states Article 143 cannot be used to review or overturn its own judgments. Advisory jurisdiction is not an appellate or review mechanism for the Court's adjudicatory rulings. The government may seek review or curative petitions to challenge the April 8th judgment instead. Pending similar cases from other states may be referred to a larger constitution bench for final resolution. Now let's talk about broader context and implications. The issue revolves around the powers of governors appointed by centre withholding assent to state bills, seen by many as undermining elected governments. The April 8th ruling empowered states to approach the Supreme Court via writ of mandamus to compel the president to act on bills within the timeline. The ruling has drawn criticism, citing concerns over judicial overreach, parliamentary supremacy, and separation of powers, voiced by Attorney General R Venkataramani and Vice President Jagdeep Dhankar. Such tussles between judiciary and legislature have historical precedent, notably the Keshavan Bharti case, 1973, which balanced fundamental rights and parliamentary power. It's time to test your knowledge, and the question is, under which article did President Murmu seek the Supreme Court's advisory opinion? A. Article 144. B. Article 143. 1. C. Article 141D. Article 142. Send the answer in the comment section. Thanks for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.